Friends, today I want to discuss about section 498A of Indian Penal Code. Yesterday, the Supreme Court of India has given a modified judgment in WP number 156 by 2017 while disposing the civil appeal number 126 by 1265 by 2017. So, this modified judgment came from three-bench judgment. So, number one, Chief Justice of India, Sri Deepak Mishra. Second one, Chandrachud. And third one, Sri A.M. Khanvilkar. Previously, during 2007, in Rajesh Sharma versus Union of India, the two bench consisting of Justice U.U. Lalit and A.K. Goyal, of course now he is retired, they have given a judgment on section 498A. Right? So this is modified. So let us first of all know what is section 498A. So friends, you may be remembering that the Dowry Prohibition Act came into existence in the year 1961 to prevent the menace of the prevalent dowry system. Of course, it was not useful. Everybody is taking dowry and conducting marriages. And later, it has become so common that a husband used to beat his wife, harass his wife. So, to prevent that, in the year 1983, an amendment was brought by the Constitution, and Section 498A has come into existence. According to Section 498A, if the husband or any relative, maybe his mother, brother, sister or any relative, if anybody puts the woman to harassment for dowry. Number two, to cruelty. Mere not speaking to the married woman, it also amounts to cruelty. There are so many meanings for cruelty. If any woman is subjected to cruelty or harassment for dowry, then it comes under 498A and the offence is punishable up to 3 years imprisonment. Okay, fine. So 1985 onwards, this has come into existence. Later, the subsequent development was section 304B. What happens if the woman is put to harassment for dowry and she dies within 7 years of marriage, then it's called dowry death and it attracts section 304B IPC. Fine, let us confine ourselves to section 498A IPC. Of course, of late, from 1995 onwards, for about 10 years or so, it was okay. But of late, it has become the most misused section. If any woman wants to take vengeance or personal vendetta against the husband, she used to file cases against the husband as well as her sister-in-law who is away to America, her father-in-law who is no way concerned, brother-in-law who is away doing some other job. So, during the year 2014, there is a famous judgment in the case law, Arnesh Kumar versus State of Bihar. So, at that time, the Supreme Court has cautioned that section 498A should be dealt with in a sensitive manner because it refers to family affairs. Right? So, during the year 2017, now, Justice U. Lalit and A.K. Goyal. So, in Rajesh Kumar versus Union of India, they have clearly stated that a stage has come where section 498A is being misused totally. So, there should be some checks and balances. So, for that purpose, in para number 19 of the judgment, they have stated that the government has to create family welfare committees. Family welfare committees. The family welfare committees should consist of paralegal volunteers and social activists. Out of them, 2 must be women and the third person may be a male or female, but he should have a postgraduate degree in psychology. That means they should vet the cases. That means they should assess whether it is a true case or false case, and then only the police will have to take action. That means, first of all, whenever a case of 498A is reported, what they will do, first of all, it will be referred to the Family Welfare Committee. The Family Welfare Committee will decide the matter and then they will recommend whether case under section 498A has to be registered or not. Of course, the Supreme Court has given time, but so far in so many states, the Family Welfare Committees were not at all formed. The second part, since it is a family issue in the Rajesh Sharma case, it was stated that if at all any anticipated bail or bail petition is filed, it should be disposed within 1 day. Third point, so if at all the families effect compromise, then the session judge has got the authority to effect compromise. That means to withdraw the case. That means according to Legal Services Authority Act. But now, since in the modified judgment, yesterday it has come, Justice Deepak Mishra has written 35-page judgment. He says that according to the judgment, present judgment, please remember, says that the family welfare committees need not be established. They can be withdrawn because section 498A itself says that whenever any woman is subjected to harassment or cruelty, then it is the prerogative of the police officer to investigate matter. Then he has got the authority to arrest the accused. If he need not arrest, he can use the powers under section 41A of the CRPC. Secondly, so there was an indication like that whenever you grant anticipated bail, normally he has to hand over the passport, then red corner notices and other things. For red corner notice also, they have to take ultimate precautions. Normally, if the husband is in America, to Interpol we used to give red corner notices. That should be sparingly given. Third part. So now, Sessions Court, now it is not competent. So whenever the family or woman puts a case under 498A, after some time they will effect a compromise. In that case, according to the present modified judgment, they have to approach the High Court under section 482 CRPC. You may be knowing, section 482 CRPC says that the High Court has got inherent powers either to discharge the matter, either to quash the matter, or things it can do. Normally, they will they will quash the proceedings, that means equal to acquittal. So this judgment is now, so previous judgment is gone because it is a constitutional bench, 2 judges, now it is 3 judges. So that judgment will go. Now this modified judgment will come into existence. It means family welfare committees, no. Then according to whenever you compromise, only High Court has to be approached. Regarding the surrender of passport and red corner notices also, due care should be taken by the courts. Please remember all these points and please go through the judgment. So this judgment is given basing on the class action petition or social action petition filed by one Forum for Manav Adhikar, Forum for Manav Adhikar, and another versus Union of India. I have in the beginning itself I told that it is disposed in WP number 156 by 2017. Thank you.